Okay, I had to switch my mic. All right, well, it's just past 1:30 now. A few more folks joining us, but we'll get started. Excuse me. My name is Eric Hauge. I'm the Executive Director of Homeline, and we're joined by Homeline's Managing Attorney and Tenant Hotline Director, Mike Raw. And you're joining us on Wednesday, December 2nd at 1:30 in the afternoon for another one of Homeline's webinars where we cover tenant-landlord legal issues during the COVID-19 pandemic. We've been doing these since about mid-April, originally every week, now every other week or so. The last one we did was back on the 18th of November, and there was a question in the chat about, is this CLE different from the Minnesota evictions during the pandemic CLE? That one was back on the 28th of October, and I'll put links to all these in the chat. The last two seminars we had on the 28th of October and then on the 18th of November were CLEs. The CLE has been approved for the 28th. I think we're still waiting on approval for the November 18th session, but the recordings of those are on our website, and I'll put them in the chat after we get started here in just a moment.
Just to jump in, a CLE, for those who aren't familiar, is for lawyers. It's a continuing legal education credit that lawyers have to get a certain number of those every 3 years to maintain their license.
Yeah, so, excuse me. So I'll put the information about that in the chat shortly, but we'll go ahead and get started as there are more people joining us. Just a reminder for folks who are joining us for the first time what Homeline is. We are a statewide Minnesota tenant advocacy organization, and our main program is a free and confidential legal hotline that any renter in the state can call. And we've been open since '92 and have advised over 250,000 households. And our programs are available in Spanish, Somali, and Hmong, as well as English. That's our hotline, the main number and the toll-free number, as well as language-specific language lines. Like we mentioned before, we were doing these to about weekly, but we've slowed down a little bit, been doing them about every other week. So we're going to take another week off, and the next seminar will be on Wednesday, December 16th. And that will be just another general seminar like today. We're not going to apply for CLE credit for today or for the next one on the 16th. We may for future events when we have guest speakers, but the purpose of these sessions are just general follow-up updates on what's going on with the pandemic and eviction suspension and related issues, and then time for plenty of Q&A. Also on our website is the registration and links to recordings for all the previous sessions, as well as a variety of materials. So with that, I will put some of that information in the chat, links to our website and such. But I'll right now hand it over to Homeline's Managing Attorney, Mike Raw. We are going to just go through a brief rundown of where we are at right now with eviction suspensions. Today, we're also going to be covering a Minneapolis-specific law ordinance that went into effect just yesterday for a specific group of landlords. And then we have plenty, we did get a few questions in advance, but we have plenty of time to answer questions live as well. So submit them via the Q&A box, and we'll get to them at the end. With that, I'll let Mike get started.
Thanks, Eric. And Eric's right, we're going to have plenty of time for questions today. Two main topics. We're going to talk about evictions, when those will be fileable again in Minnesota, and also, as Eric mentioned, the Minneapolis ordinance relating to, well, a tenant applying for a rental unit, and limits on security deposits are what we're going to focus on there. But we're going to start today with the question that we've been asking since we started doing these webinars in April, which is, when will Minnesota landlords be able to file evictions again? And we're going to try to answer that by looking at the hurdles that a landlord would have to get past or over in order to be able to file an eviction for non-payment of rent. That's really the prime focus of eviction questions in Minnesota because, well, over 90% of Minnesota evictions are for non-payment of rent. And so that's why we zero in on that issue. And there are really 3 hurdles that a landlord would have to get past, legal hurdles that are in their way right now, in order to be able to file an eviction. The first and the most important one from a Minnesota landlord perspective is the Minnesota-specific moratorium. So this is a state-specific rule. It's not the rule in any other state, although other states have some rules that are similar. It's based on an executive order from the governor. Well, the first version of that was issued in March, and it's been updated a couple of times since then. But it is tied in time, the governor's executive order banning evictions, to the peacetime emergency. So the peacetime emergency is something that everybody in Minnesota is familiar with. This is what authorizes the governor to declare that restaurants have to close, or salons or bowling alleys or movie theaters have to close, or when the governor decides to relax the rules to open them back up and maybe they can have 50% seating or something like that. The peacetime emergency statute, which authorizes and gives the governor that kind of power, is limited in time. It is a 30-day increment each time when the governor has the right to declare a peacetime emergency, followed by another peacetime emergency. So the governor, it seems, can indefinitely continue to declare peacetime emergencies. However, there is a check in place statutorily on the governor's power in this regard. Legislatively, the House and the Senate, the Minnesota House and the Minnesota Senate, could vote, both of them would have to vote with a simple majority, to end the governor's peacetime emergency if they so chose. Now, the Minnesota Senate and Minnesota House have actually voted several times on that very issue this year. Every time the governor reauthorizes the peacetime emergency, the legislature has the opportunity to vote to end it. If the legislature is not in session, then a special session is immediately triggered. We've seen this several times this year. And every time except the last time, there has been a vote. And the Minnesota Senate, controlled by Republicans, has voted to end the peacetime emergency. The Minnesota House, controlled by Democrats, has voted not to end the peacetime emergency. Back in November, the last time there was a vote, or there was supposed to be a vote, I don't think there was even a vote held. It was after the election, and the COVID-19 had started re-accelerating in Minnesota, the number of cases, the number of fatalities, and so I don't think it was even voted on in November. And so the current Minnesota moratorium ends officially on December 14th, so under 2 weeks from now. Will it be extended again? That's always the question. It's the biggest question. This is in landlord-tenant law in Minnesota, this is the banner headline, and it has been since March. Landlords can't file evictions for non-payment of rent. And so we don't know whether it's going to be extended again or not. We have no inside track. We don't have a source inside the governor's office telling us how long the moratorium is going to be in place for. I do believe that this is what's happening, that every month the governor decides, do I need to continue doing this? And I think that deep down the governor hopes every month that he won't need to continue to do this because it's a tough political position to be in. The governor realizes that every time he does this, that there are factions across the state that are unhappy with him. And so he knows that there's a political cost to doing this. And so I think he looks at the numbers. Like I said, the hospitalizations, the number of intensive care beds, the fatalities, and tries to decide based on that whether to keep the peacetime emergency going. And until and unless either the governor stops reauthorizing these peacetime emergencies or the legislature ends it, again, a simple majority in each chamber, or the Minnesota courts somehow rule that this isn't valid. This is what we've got. And a landlord can file an eviction in Minnesota for a few different reasons. There's some exceptions built into this executive order. And I'll just briefly state them. We've talked about them at length at other times, but here they are. If the tenant is seriously endangering others on the property, if there's significant property damage caused by the tenant, if the tenant has violated a specific law that predates the pandemic that refers to not allowing drugs, illegal weapons, prostitution, stolen property in the rental unit. That's still in place. A tenant can be evicted for that. And the other big exception is the family member exception, where a landlord can tell the tenant, if it's a month-to-month lease, the landlord could give a notice for the end of the next month or something like that, saying, I'm going to move in, or my family member is going to move in. And so that's what we've seen for exceptions. Are there evictions being filed in Minnesota? Sure. But it's nowhere near the volume that we have in normal years because, again, well over 90% of Minnesota evictions are for non-payment of rent, and landlords can't file for that reason right now. The next hurdle, just moving on to the hurdles, and then we'll sort of talk big picture here. The CARES Act. So this is federal legislation, and this is actually legislation versus an executive order. This was passed back in March, I believe it was March, and it passed at the federal level. So it went through the Senate, controlled by Republicans, went through the House, controlled by Democrats at the federal level, and was signed by President Trump. And it stayed evictions or stopped evictions from being filed in a building that was covered by the CARES Act, which wasn't every building in Minnesota. Not every rental unit in Minnesota would be covered by this. It would be large buildings where there's a subsidy, or any building where there's a subsidy, frankly, any kind of government subsidy from the federal government. The biggest umbrella, easiest way for folks in my line of work to figure out whether something is covered by this is whether that rental unit is covered by VAWA, the Violence Against Women's Act, which it actually refers to in the federal legislation. Additionally, an owner who has a mortgage that's federally backed, which is very difficult to know unless you're actually the mortgage holder. In fact, you might not even know that if you're the mortgage holder yourself. You might have to go to your bank and figure out whether or not you've got a Fannie Mae or Freddie Mac backed mortgage. So it was probably somewhere between 20 and 50% of Minnesota landlords that would have been covered by the CARES Act. However, the CARES Act sunsetted, at least the eviction prohibition, sunsetted, as they say in legislative ease, on July 25th of this year. So it's done. However, after July 25th, the landlord still has to give a 30-day notice if they're covered by the CARES Act. So that's hurdle number 2. It's the least difficult hurdle of the 3 that we're going to talk about. If you could go to the next screen, please, Eric. Thanks. The last order is the CDC order, which is also a federal order. This was not legislatively agreed upon. This was an executive order routed through the CDC, the Center for Disease Control. It's a fair question to ask, why does the CDC have the power to issue an eviction ban or moratorium? In fact, it's such a fair question that it's been challenged in court at the federal level, unsuccessfully so far. As I think it was in Georgia, a district court in Georgia that heard a group of landlords that were filing a case saying that this was unconstitutional, and they listed sort of the usual unconstitutional suspects in this line of thinking. And the first court, district court, said, no, this is legal, the CDC can do it. So it's still in place, it's still in effect, and it lasts through December 31. I admittedly, my boss Eric has said that I've been watching too much YouTube today, which is true. I've been doing some research both into the Minneapolis ordinance that I'm talking about today, and along with the CDC order. And yeah, I found one landlord site, and they were talking about the CDC order, and they were convinced that the CDC order was going to be renewed. I'm not sure for how long, but they were convinced that there was nothing that was going to change on January 1. I'm not as certain of that prediction. I think that might just be kind of a pessimistic landlord view here, which I can certainly understand based on what's happened in the last 9 months with landlords trying to collect rent, that they might think, hey, we're never going to catch a break. That's how landlords are viewing this in many ways. And in a lot of ways, it's true. But I'm not as certain that the CDC order will be renewed. I don't know that it's certain. I think that January 1st, it's possible the CDC order could get extended. I think it's also very possible, if I had to bet, I'd probably bet that it won't get renewed. But then we're going to have a change in the White House on January 21st. And so is there a chance that we'll have a 20-day gap between this CDC order and whatever President Biden might decide to do on January 21st? Hard to know. I think it's very possible that there's going to be another federal moratorium, whether it's going to be legislatively agreed upon or, once again, an executive order routed through either the CDC or somebody else. Hard to know. But what we have today, and we still have in place, is this CDC order. Now, it doesn't really matter in Minnesota. Not really. It's more of a backstop than anything else. I guess if the Minnesota moratorium ended on December 14th, which is always a possibility, then the federal CDC order would still be a backstop that would stop a landlord from being able to file an eviction through the end of this month, the end of this calendar year. So it still has a role here in that it's been sort of this backstop. And having listened to some of the floor arguments at the Senate and the House in Minnesota, where they talk about whether to end the peacetime emergency, in months before the CDC order got issued, which was in early September, this was something, the eviction moratorium was brought up regularly in both the House and the Senate, where members would talk about how landlords weren't able to file evictions for non-payment of rent, and that it was, you know, something that their constituents were upset about. Since the CDC order came into place, it's not talked about anywhere near as often at these floor sessions, because even if the moratorium went away on evictions in Minnesota, the state-based one, this federal one was suddenly in place. And it wasn't just in place, it was in place for a long time. No 30-day at a time chunk like with the state order. This was through the end of the calendar year. This is the rule that everybody's gonna have to play by. Now, the CDC order is a little more limited. It only protects tenants facing eviction for non-payment of rent versus the state moratorium, which, for instance, a landlord cannot evict for an unauthorized occupant. The boyfriend or girlfriend has moved in with somebody, probably the most common version of that story, and the landlord wants to file an eviction for an unauthorized occupant. In general, that's probably the second most common reason why landlords file evictions in Minnesota, but right now they can't file it. Tenant brings in a pet that they're not supposed to have. Can a landlord file an eviction for that? No. Unless somehow the pet is seriously endangering others on the property or has caused significant property damage, the landlord couldn't file an eviction for that pet. So the state rule is more expansive. And as mentioned, the CDC order explicitly says if there's a state rule in place that's got more protection for tenants, that's the one that matters. And so that is the one that matters in Minnesota. Now, under all of these rules, the state order, the CARES Act, the CDC order, the rent is still due. The rent hasn't been forgiven. The rent hasn't been wiped out. There's been no rent cancellation. People talked at great length in many places online and in the media about rent strikes. The rent is still due. So there's still an accruing debt for a tenant that hasn't paid rent since April. Are they out there? Yes. Is it a lot of tenants? I don't think it's a lot of tenants, but it's some tenants. And there's no rent cancellation that's happening. Another question that we get a lot about this is, can a landlord charge late fees right now? The only one of these three orders that said anything about late fees was the CARES Act, and it did not allow late fees if it was a CARES Act covered building through July 25th. So even with the CARES Act, every landlord can now charge late fees. And that's always been the case with the state moratorium. The CDC order does not stop late fees from happening either. So the late fees question is absolutely yes. Right now, a landlord can charge late fees if it's in their lease and it complies with state law about late fees. And that's been the case since July 25th. So we did see an increase in landlords charging late fees, certainly starting in August of this year, which I guess was to be expected. And questions about that have spiked up for us as well. Okay, let's go on to the next topic.
Yeah, I'm unmuted hopefully. I was reading the Washington Post while you were talking there, and there's discussions, happening on the federal level right now every day about some sort of stimulus plan, but it's right now saying there's not necessarily agreement, and even the package that the Democrats are trying to push forward does not mention anything about the current eviction moratorium and if that would get extended. So still a lot of lack of clarity on the federal level, like you were talking about. Did you want me to talk about this one?
Sure, go ahead.
Yeah, so this is just something new that we wanted to share for folks that maybe haven't seen it yet. There's this study that the caveat is, of course, that it's very recent. It was just released on Monday. It does not yet have any, it has not been peer reviewed yet. And I'll put the citation and the link to it in the chat, but basically that's what you're seeing right there is most of the abstract. And what they did is they looked at some of the states. There are 27 states that lifted eviction moratoriums. And this is from March 13th to September 3rd. So September 4th is when, that's when the CDC one went into effect, I think?
Yeah, September 4th, right.
Yeah, so that's why they did that so this is the time period before that went back into effect, or that went into effect. And so, and they they controlled for a variety of aspects about what different states, the level of protections that some of these states had in terms of mask orders and those types of things. And they came up with this estimate that the states among these states that did lift their state moratoriums, there's this estimated over 430,000 excess COVID-19 cases and an estimated 10,700 excess deaths as a result of potentially as a result of the lifting of those suspensions during that period. So again, March 13th through September 3rd. So again, this is a very early, but it's not been peer reviewed, but it's coming from a lot of substantial researchers, and I did put the citation, the links in the chat. Just a really disturbing look at what's happening in other states where there aren't as protective suspensions as Minnesota and some of the others.
And I think this is when we're asked by landlords, why are these moratoriums in place? A question that we've gotten virtually every time we've done one of these sessions, where landlords are welcome to watch and learn all the rules that we're talking about, and we invite them and we are happy to have them join us. But we've been asked, why are these moratoriums in place? This isn't fair to landlords. And I think this is what is behind all of this, right? Behind all of these moratoria. Again, the state one, we've heard since the state moratorium was put in place from a wide variety of landlords saying this is Governor Walz's fault because he's the one signing these executive orders. Nobody else is clearing them, and he gets to sort of dictate the terms here. But in September, President Trump, a very different political animal than Governor Walz, issued a similar order. And I think if there's one consensus, it's that we don't want people to need to move around a lot right now. And they're trying to figure out how to do that in a lot of different areas. But this is one that we're seeing, and this is why we're seeing this, is because, well, we're going to have people doubling up if they're evicted. We're going to have people moving to shelters. And so I think this is a really depressing statistic to look at, obviously. But it's not as bad as it could have been, clearly, if we just decided societally to, well, evictions should happen as planned, and mortgage foreclosures and things like that as well. So it is chilling, as Linda just pointed in the chat box.
All right. So again, that was our overview of where we're kind of at right now in Minnesota with the moratorium and other related issues. There's plenty of other topics that renters do contact us about the pandemic, and I did put the links to our website. We have FAQs about Executive Order 2079, the current suspension order, as well as the mask requirements and other issues related, like privacy issues related to residential tenancies. So you can see that, but feel free to submit questions about any of this. We did get a couple in advance, but we'll have plenty of time to answer them. Now we're going to go on to a topic that we did cover back in June because the city of Minneapolis last year enacted some new local city ordinances that impact tenancies, and they kind of split it up. I did double check, and the deposit one was in effect for everybody back in June, but the tenant screening one had a delayed implementation. So now, as of yesterday, all landlords are impacted. So I'll hand it back over to you, Mike.
Right. So we had the staggered implementation of this ordinance, which happens sometimes. It's a little bit clunky, honestly, when it comes to legislative enactment. The theory was that sophisticated big landlords that have 16 or more units would be able to adapt more quickly to the new rules that Minneapolis had put in place for tenant screening, and that the small time landlords, the mom and pop landlords, the amateur landlords, the accidental landlords, whatever phrase you might want to use, were left with a little more time to try to implement into their screening process. So I'm going to talk about this. It'll feel like it's in depth, but I'm going to try to be as summarizing as possible. That's really my goal here, because there are a lot of technical pieces to this, and I've watched webinars that last literally 2 hours talking about the minutiae of these things, and that's not what we really need to do. We're going to have sort of a broad introduction to what they are. As Eric mentioned, we talked about this in June, but we're talking about it again right now. Even though it's not COVID related at all, this ordinance was drafted long before COVID-19 was ever spoken, I think. And it had a start date in the future. So it's one of those things that is not COVID-19 related at all, but it's coming up right now, and it's happening effectively yesterday, applying to all Minneapolis landlords. This is what we're talking about for the next few minutes is going to be just about Minneapolis landlords. Those are the only ones that are affected, and tenants obviously, or applicants in Minneapolis. So there are two approaches that a landlord can take when it comes to tenant screening going forward in Minneapolis. The first is what's called an inclusive criteria. The other is the individualized assessment. And we're going to walk through each one of those things. So first, the inclusive screening option. This is where the landlord would use guidelines essentially drafted by the city. The inclusive screening option talks about the 4 big areas that landlords do tenant screening in: rental history, credit, criminal record, income. And it's got new parameters that landlords have to use. So when it comes to rental history, which is having spoken in person back when I used to give in-person speeches, I've talked to hundreds of landlord groups all around the state. And if I ask them, what's the first thing you look at when you're doing a background check? Is it criminal, credit, rental history, income? What is it? They always say rental history. Why rental history? Well, I'm a landlord, and I want to see how this tenant has interacted with other landlords. And it really matters to me if that other landlord filed an eviction against them. So I care about evictions more than anything else. It's the first thing that I want to look at. Using the same sort of jargon I was using earlier, it's the first hurdle for a tenant to get a yes from a landlord when applying to that place, is can they get past the rental history question? And what we're really talking about when we're talking about rental history is evictions. An eviction, also known in this state as an unlawful detainer or a UD, what that means is that a court case was filed against a tenant. Doesn't necessarily mean that the landlord won the case. In fact, a lot of landlords don't even look at the result of the eviction. All they care about was that an eviction was filed. And I'm generalizing now, Minnesota landlords in general, if they're doing a background check, they can turn a tenant down, Minnesota rules, because an eviction was filed. Doesn't matter if the tenant won, lost, or drew the case. The landlord can turn them down for that. This Minneapolis ordinance is trying to address some of that. So a landlord can't use an eviction to say no to a tenant. That's really what screening is about. When can the landlord say no for something versus when can they say yes? And these are the screens that landlords will use. And now a landlord in Minneapolis can't use an eviction if it was dismissed or the tenant won the case. Okay, so now that's a change. There's no question about that from state law. Minneapolis is the only city in the state currently that has a rule like that. If the case was settled and no writ of recovery was issued, and it was over a year ago. So a writ of recovery is the final order that a landlord gets if they win an eviction against the landlord. Against the tenant. It's the piece of paper that the landlord takes to the sheriff's office and says, "Sheriff, I need you to help me enforce my judgment against the tenant, the eviction judgment. I got this writ of recovery, and I need you to go remove the tenant." The sheriff will actually go twice to remove the tenant. The first time they'll put a note on the door saying, "Tenant, you've got 24 hours to go." After that, the landlord calls the sheriff back again and says, "They're still here. We need to schedule a move out." The second time the sheriff comes, the sheriff will show up with guns on their belt and a team of guys or whatever it is saying it's time to go. The force of the state is the final act in the eviction process. The last exception, and this is probably the biggest one, this is the biggest net that they're using here, is if the eviction is 3 years old, if it's over 3 years old. So as it stands, the screening companies that most landlords hire will be able to look at an eviction that's 7 years or newer. They can go up to 7 years, but not past 7 years, based on some federal laws. This is shortening that time frame that a Minneapolis landlord can look back to 3 years. So this is arguably the most important change that we're seeing in the screening approach, at least if a landlord is willing to use the inclusive screening option put forward by Minneapolis. Let's talk about the other 3 components, and then we'll talk about the other option a landlord has. So the criminal history, again, rental, criminal, credit, income. Those are the 4 things that landlords tend to look at when they look at a background check, where they, again, typically hire one of these companies. There's about 10 companies at any one time. Tenant screening companies, landlord screening companies, they sort of go by the same general name. If you Google up either one of those things, you're going to find the same companies in Minnesota. They look at those 4 things. They charge tenants somewhere between $20 and $50, maybe $75 an adult we've seen on occasion. And landlords typically pass that cost on directly to the tenant. At least they have historically. Depends on market forces to some degree, but that's historically what they've done. In the criminal history, the new Minneapolis inclusive screening option limits how far back landlords can look in certain areas, and it depends on what you're looking at. It's a misdemeanor, 3 years, felony, 7 years. Specific felonies, you can guess what's on that list, and there is a list in the actual code ordinance, older than 10 years. Let's go on to credit as well. So credit scores, we all have a credit score. Every adult in this country has a credit score, whether they want one or not. Typically, the scoring system goes from 350 to 850. Some landlords require 550, 575, 600, 625, 650. I've seen one as high as 700, just one. But right now in Minneapolis, if a landlord's using the inclusive screening option, they can't use credit alone to deny an applicant. A landlord can't simply say you must hit 600. They can use the credit information. So sort of looking at what the reasons for the bad credit are. Hey, did they not pay their rent before? Did they not pay utilities? Things that landlords care about specifically versus something like a medical bill, which might knock somebody's credit down terribly, but does it really have an impact on a landlord is kind of what this ordinance is thinking about. A lack of credit history also can't be used against an applicant. So people just starting out, people brand new to the country, can't be turned down simply because they don't have the right credit score or the lack of credit history. Jumping over to income, again, what a lot of landlords will do in Minnesota is they'll say, look, tenant, you can't get this place unless I can be assured that you're going to be able to afford the place going forward. So I need to see 2 times the rent and income, or 2.5 times the rent and income, or 3 times, or I've seen as high as 4 times before. And so this says the landlord has a 3 times or higher requirement. Then the landlord has to allow applicant to demonstrate they can meet rent obligations, to prove that they've been paying rent at a similar amount somewhere else, or maybe their income is bumped up, or whatever explanation they might want to give. So that is a summary of the inclusive screening option, which is, like I said, Minneapolis more or less saying, hey, landlord, look, these are criteria you can use that the city is essentially approving. We've created them for you to use to decide who to rent to. Now, a landlord, if they use one of these inclusive screening options, can have more relaxed things. They could say, oh, you know what, the income requirement says 3 times or higher, but I'm going to let you explain things if I have a 2.5 times income requirement. Or I'm only going to look at evictions that are 2 years or newer instead of 3 years, because I want to give tenants a break, and I figure somebody from 3 years ago, especially if they're just starting out, they're a very different person than they were 2 years ago. A landlord can be more relaxed with their screening criteria. They can't be more strict, though, is how it works. Let's go on to the individualized assessment, which is the other option that a landlord has. So this is more complicated. I honestly think this is something that is more likely, and we've seen a bit more of it with the larger landlords to try to use. The individualized assessment's a higher degree of difficulty to do right. Look, the key concept driving almost all tenant screening in Minnesota, and I think throughout the country, is landlords are concerned that they might be sued for a discrimination suit. Using the city's the inclusive screening option is, I think, legally much safer for a landlord to avoid a discrimination suit. They can say, hey, look, I'm following the city's parameters. They thought about this and had teams and committees, landlords, tenant, landlord advocates, tenant advocates, lawyers, all kinds of lawyers looking at the stuff endlessly. They thought about it all and they decided that those criteria were good. So I think if you want to, as a landlord, be protected more from a discrimination suit, you follow the Minneapolis first option, the inclusive screening option. And my hunch is that landlords that own under 16 units are more likely to go that route. I think it's easier to comply, frankly. But we've seen some landlords that have decided to try the individualized assessment. I think it does absolutely push them further out on the, am I going to potentially get sued for a fair housing violation and discrimination? I think it's more possible with the individualized assessment. But it is in the ordinance, and it's something that a landlord is allowed to do. So if a landlord wants to go with stricter criteria, then the landlord has to conduct an individualized assessment for any basis they deny an application. Just go on to the next slide and we'll cover all of this and sort of summarize it in a second. So what this means is, among other things, the landlord has to allow the tenant to add information. If there's some kind of knock on the tenant's past, that the tenant has a chance to explain it, and how often it happened and when it happened, and what happened. And look, if you're 25 and you're applying for a place and you got evicted when you were 21 or 20, maybe you're a very different person at that point, right? Now you were just out of high school or maybe in college versus, you're out working, you've been working for 2-3 years, maybe you got a family now and a kid, very different person, obviously. So these are the kinds of things that a landlord would have to consider if they're doing the individualized assessment. Going on to the next slide, we have sort of a comparison along with a couple general rules. So in both cases, the landlord, whether it's the individualized assessment or the inclusive screening, the landlord has to state within 14 days in writing the criteria the applicant failed to meet, which is a new thing. In state law in Minnesota, it's not required for the landlord to say which criteria that the tenant didn't meet. They could just say, we're denying your application, which a lot of landlords, that's how they did that. But now they have to state what part you didn't meet. These were our standards, you didn't meet them. If it's the inclusive screening, which is once again, the city sort of created screening criteria, then if it's the criminal history, the landlord must have considered whatever supplemental evidence was provided. And in the individualized assessment, the landlord has to state that whatever supplemental information the tenant provided wasn't sufficient as well. Landlords are required to keep these records for 2 years. Again, this is a new thing. State law doesn't require this. And these can be reviewed by the Department of Regulatory Services. That's who's enforcing these rules. The city is. And ultimately, that's where the power to enforce this comes from. They issue licenses to Minneapolis landlords, and so ultimately they are in control of the licensing, and if things get bad enough with some landlord, they could say your license potentially could be in peril. There's other phases of penalties that the city can use other than simply taking away a landlord's license, but it is the biggest one at the end of the day that they can exercise. Again, these are changes. There's no question about it. From state law, these are very real changes to what's allowed. I can say that this has been challenged already in court. I mentioned that the CDC order had been challenged in Georgia. A group of Minneapolis landlords challenged this ordinance in federal district court instead of state court. A little surprising that they chose federal court, but they did. They chose federal court. They filed for a what's called a preliminary injunction against the city, saying that they shouldn't be allowed to enforce this ordinance. And they cited, again, a long list of pretty common constitutional arguments that you see in cases like this. The sort of concept in general is that the government is taking the landlord's property by whittling away at the rights that a landlord has on who they get to decide to allow to live in their place. There's other pieces to the argument that they're making, but that's kind of at the core of what they're arguing. And the judge in the preliminary injunction looked at a lot of different sort of predictive factors, and that's how preliminary injunctions work, is that the judge looks at a lot of different things. You know, how much of a difference does it make that I act right now? Do I have to act urgently? Or what are the likely chances of success that this case is going to have on the merits, which is the first thing the judge in that court looked at. And the judge said they don't have a very likely chance of succeeding. And so that kind of dictated the rest of the findings. And so I think that this is likely to hold up to judicial scrutiny. Are landlords going to appeal that first decision to the Federal Court of Appeals, or maybe try their luck in the state court? I'm not sure. A similar type of argument was made by a landlord group with Minneapolis's Section 8 ordinance, which was enacted a couple years ago, which said that Section 8 was basically a protected class in Minneapolis. A group of landlords challenged that. The landlords actually won at the state court, at the district court level. That's the first court you go to. The city appealed to the Minnesota Court of Appeals and won there. The landlords appealed that to the Minnesota Supreme Court. The city won there. And so are landlord groups going to get tired of trying their luck in courts to try to overturn these ordinances? Not sure. Maybe they'll keep going. But I have to think that the city is pleased with the status of all these court cases at this point, as courts seem to be supporting their right to enact meaningful tenant protections. And this is a substantial expansion of tenant protections. There's no question about this. This is not especially common throughout the United States. I think that this ordinance was drafted largely modeling Seattle's, which is one of the more progressive cities in the country when it comes to tenant rights. Trust me, this isn't all they do. They do a lot more in Seattle than this. I'm not sure how much more Minneapolis is considering, but with a string of successful court cases, they might be considering more. Let's talk about the next part of the tenant protections, the security deposit cap. Once again, only in Minneapolis is all we're talking about right now. This is a new rule in Minneapolis only. So it's capping how much landlords can charge for a security deposit. So we all know what security deposits are: security, damage deposit. They're termed different things, but they mean the same thing. The landlord takes money up front, is supposed to return it to the tenant within a few weeks of the tenant moving out, along with interest. In fact, it's the tenant's money. The landlord is just holding on to it. And landlords have, over the years, asked for more and more money up front. I can tell you, talking to tenants on our tenant hotline, where we take about 15,000 calls every year, 2 times the rent for a deposit. So the landlord asking for a month's rent, maybe the last month's rent as well. So first and last month's rent plus a double deposit. First and last plus a double deposit plus an application fee. So if we're just using $1,000, which is kind of easy to look at the math here for rent, a tenant applying for a $1,000 a month apartment in Bloomington, for instance, does not have the Minneapolis ordinance, might have to pay $4,050 to get a $1,000 a month apartment. They might have to have $4,050 in their pocket to hand to the landlord on day one when they're applying in order to get that place. In Minneapolis, that has been capped. Now, a landlord can only ask for 1 month's rent for a deposit. If the landlord wants to do that first and last month's rent, then the deposit gets shrunk to $500, half of the first month's rent. So a landlord could get $2,500 up front. Are we going to see more last month's rent charged in Minneapolis? I suppose we could. Sort of the theoretical problem with the last month's rent from a landlord's perspective is, the good news for the landlord is they don't have to pay interest on it, right? The security deposit, look, it's not a lot of money. It's 1% simple interest. It's a lot better than you do in your checking account these days, or would have done for the last 15 years. But a landlord does have to pay interest on a security deposit. They don't have to pay interest on the last month's rent. So that's, from a landlord's perspective, good. The bad news for the landlord is they've named the last month's rent, right? They said you paid the first month's rent, you know, let's say you moved in January 1st of next year, and you've also paid December's rent of next year. But what if you stick around for 4 or 5 years and the landlord raises the rent, you know, $50 every year per month? You've already prepaid the last month's rent. At least that's the argument. It's not something that we've seen litigated at the highest levels in the state, but I actually think that's probably the right assessment legally, but we'd see. So anyhow, there is a potential downside to a landlord insisting on a higher last month's rent to try to get more money in their pocket under the Minneapolis new ordinance. Now, if the tenant got the rental through a referral from a nonprofit service provider or government agency, the deposit limit can go up. The city's trying to give landlords more incentive to take a chance on somebody that might be coming out of a domestic abuse situation or all kinds of subsidized housing or a shelter place, transitional housing, I should say, or a place like that, and try to give landlords more of a financial incentive to take a risk. And so that is a heightened deposit allowed there. Okay. A big picture question about this stuff is that I'd like to address, which is why is this happening? Why are we seeing Minneapolis do this? And by the way, this is the front of the, we're not sure the size of the wave, but the front of the wave of tenant protection ordinances in cities in Minnesota. St. Paul, we can give a speech like this, probably very similar, on March 2nd of next year. March 1, St. Paul is going to be enacting similar ordinances along with the first just cause ordinance that we've seen applied for all tenants in Minnesota next March. So they're going even further than the Minneapolis ordinances have done. Eric, I think you mentioned that St. Louis Park is has actually enacted the notice requirement for a landlord to file an eviction. Do you know when that's supposed to go into effect?
Yeah, just they had first, second, third readings throughout November, and it's passed, I think, unanimously on the St. Louis Park Council, and it is effective January 1st of 2021. And so that would require for evictions for non-payment a 7-day notice to quit.
And that's the first one we've seen of those, correct?
It is, yep.
Yep. We're also seeing some cities abandoning something called the crime-free multi-housing addendum. Which cities do we know of right now that have already decided or have eliminated using that?
So yeah, that started back a couple of years ago when the city of St. Louis Park, again, there was a TV investigation about the impact of their local crime-free ordinance. And so after the investigation, there was a community work group that got together to, actually first the council put a temporary suspension on it, and then a community work group of tenants and landlords and advocates and community members discussed it over the past year. And then I think it was just, I'm going to forget the dates, but I think that one is currently effective. They've repealed the vast majority of their crime-free ordinance a couple months ago. And then in August, actually, they approved those amendments that repealed almost all of the crime-free provisions. And then the other ones, in late October, the city of Robbinsdale approved an interim ordinance that places a 1-year moratorium on the enforcement of their crime-free ordinance beginning last month. So it could be up to 1 year or less if the council decides to repeal it sooner. What they're going to be doing in that year is the ordinance authorized a study about the ordinance and its impact. So they're going to kind of put it on pause and look and decide if they want to take permanent action. And then lastly, Golden Valley just, I believe last week or maybe 2 weeks ago, had second or third reading of their repeal. And so that, I believe, is effective now. It was published in the paper. So they ultimately, my understanding is they repealed almost all the provisions of their crime-free ordinance. They retained some training aspects, but yeah, police involvement in, potential threats of license revocation and those types of things are more or less removed.
And Eric, you and I have been in this world for quite a while, and cities have always had some involvement, some more than others. But I think it's safe to say that we're seeing a new phase at this point, right? In cities trying to expand tenant protections. Is that fair to say?
I'd say so, yeah. And I mean, it's coming off other things that even more cities have done. I mean, one that started a couple of years ago and is now in multiple cities, including Minneapolis, St. Paul, and then a lot of the suburbs, is our advance or notice of sale and some limited tenant protections when there's apartments sold. So yeah, it's definitely there's been a lot more activity here in the past couple of years, and just in the past year, I think considerable amount of changes.
And you work at the policy level with a lot of this stuff. I mean, you get asked by city council members or legislators, you know, does this rule make sense? Why do you think cities are doing this? Why do you think they're taking on this new heightened rule?
And then there's a variety of factors, but I think I mean, just the way the rental market has been over the past 5 to 8 years, and the vacancy rate has just had a tremendous impact. The lack of affordable housing just puts a pinch on this end of the market, and makes it very difficult. We've also seen some really egregious actions taken place by some landlords, and there's been lawsuits, and I mean, one of them we were involved in, and it resulted in a city enacting a new ordinance. So and then there's a lot more, I think, just knowledge and community organizing and community education around these types of things, and people are learning more. There's more opportunities to organize. I think also just in the context of where we're at in the pandemic, and that we're doing these virtual sessions. I mean, I started at Homeline as community organizer, and it was always door knocking apartments. It's a little bit more difficult to do that now, but it is somewhat easier to connect one-on-one or even in groups with people virtually if folks have the means, which is always technology is sort of can be an equalizer, but can also be a challenge there. So I think that a variety of factors have influenced it.
I guess what and I appreciate what you're saying, but generally, landlord-tenant law really hinges on state laws.
Right, yeah.
That's kind of the driving factor behind everything. And so it really is not difficult to predict a patchwork of laws throughout, certainly the metro area, but I could see such things expanding to other smaller metro areas in Minnesota as well. Sure. Where we'd have almost metro-specific rules and non-metro specific rules, because laws are a lot harder to change at the state level, right?
Yeah, I think that's another good point, is that, yeah, we haven't seen really substantial changes in state law in close to a decade. There's been some fixes here and there, and even beyond that decade, I mean, the somewhat minimal changes from the grand scheme of things in terms of how a lot of these processes work in tenant landlord law. There's one other thing I'd also add maybe too, and that is that I think, and this is having an impact at the state level, I think now too. We just saw this week the House Minnesota Legislature House DFL caucus, whose leadership in the House, because they have the majority, announced their committee structure, and there's two sort of designated housing committees, one housing committee and one focused on homelessness. There's a much larger, there's more and more elected officials, both on a state level and I think on a city level, that represent this population more, because they are renters, and they know
the legislators themselves are renters.
Legislators, city council members, they are renters, or they were just very, very recently renters, and they know the struggles and some of the experiences that they faced or their family and that of their constituents. And so I think that's increased too, especially I think on a local level. But again, I think now you're seeing it even more so on a state level with some of the new elected officials.
And I had mentioned that the screening ordinance was largely modeled after Seattle. The security deposit ordinance, which again, we're going to see a version of something like that in St. Paul in March, along with the screening ordinance and the just cause ordinance. And if we're still doing speeches like this, I'm sure we'll do one in March on St. Paul's new rules. The security deposit rule that Minneapolis adopted was not a very unique approach. There's something like this in, I think, more states than there aren't. I think there's more states that have some sort of security deposit cap of some level than don't. Minnesota does not have a cap on security deposits. So Minneapolis taking this step might seem bold and radical, but it's not really radical. The screening ordinance is a bold step, I think. They're not the first that came up with this. They didn't invent this, but the security deposit one we're actually, I think, well behind the norm on caps on security deposit here in Minnesota.
Yeah, I think there are multiple states that have security deposit type things on the state level, but yeah, not a lot of screening.
Yeah, every legislator, whether they're at the city or the state level, if they're thinking about a problem that they're wondering, can we solve the problem with an ordinance or a statute, they'll look and see if other ordinances or statutes exist somewhere else. And if possible, use those as models. And, create it, adapt it to their own situation, obviously, but they will look at that. But hey, enough about what I wanted to talk about. Maybe we should get to some questions today.
Yeah, and before we get to the questions, there's one other thing I was just going to raise an issue, and not really an issue, but I'll put it in the chat. This is just an important thing, and we've tried to sort of mention it as much as possible to just get the word out there. But and you already explained, in the context of our eviction suspension here in Minnesota, that rent is still due. And has been due every month, and so it has added up in some instances and may continue to do so. There is a statewide program through Minnesota Housing, and I'm putting the link in the chat here, of the COVID-19 Housing Assistance Program. You can dial 211, or you can go to housinghelpmn.org for renters to apply. The applications for this are due December 7th at right before midnight online, or if you're mailing a paper copy, you have to mail it. You get it postmarked by December 7th. Now, this is because this program is primarily funded by the CARES Act, and that money basically sort of has to go back at the end of December. So just an important thing to get the word out there that on a statewide level, renters, advocates, landlords get the word out to tenants that they should apply here. There's also county level assistance, and some of those are more flexible. We always just suggest in most cases to dial 211 and find out, based on your location, what the best thing to access is. But that's that. And
yeah, that December 7th money, from what I understand, that's not going to likely come back. That's just gone on December 7th. And so I think you've got tenants out there that might be thinking, hey, the landlord can't file an eviction, so the rent isn't really due. Like we talked about, the rent is due, and this might be the one chance you have to get access to that money.
Exactly.
Or will be the one chance for that specific money.
Yep. I think they're trying to figure out workarounds, but they're sort of setting this deadline. And I also just put a link in the chat that we'd shared in a previous week that's updated as of this Monday, that has just data about the applications that have come in and the money that's been spent out of that program. So it's getting used, but there's a deadline on it. And I do know that the state legislature, they're going to be coming back for a special session. Likely it's sounding to happen next week, because if it's not next week, it'll have to be probably around the 14th or before. The 14th again is the end of the peacetime emergency, though. So that's when that could get extended, but they're also talking about bigger packages in terms of more rental assistance and other programs like that. So okay, I will let me find the questions here, and again, we have a half an hour if we want to use it.
And we have two questions in the queue so far. So yeah, you're going to get your question addressed if you get it in the next 15 minutes or so. So please feel free to ask whatever you'd like about what we've covered today, or any other landlord-tenant legal questions in Minnesota. We'll be happy to try to answer what we can.
Yeah. Okay. I'm going to do these in reverse order here. Barb asked, "Can my new owner raise my rent by 30%?" That's
a real specific question. I like the fact that Barb put the number in there. Rent increases are limited right now during the COVID pandemic by another executive order. One of the older ones that I think is unchanged. I think it's 20-10.
Yep.
And when you're looking up executive orders, how you look at them, it's how it's usually defined as EO. So that's the executive order 20, which is 2020. And then in this example, it's 10, 10. I think we're into the 90s now. Maybe we're up to 100, I'm not sure. Executive orders that have been issued by the governor this year There are executive orders issued most years, which I hadn't really realized until I'd looked at this year because it didn't matter in my prior years. But obviously they have an outsized importance this year. So this specific one, the price gouging order, says that somebody who sells or provides essential services or goods, and housing is certainly on that list, cannot raise price more than 20% above what it was prior to the pandemic. It defines what prior to the pandemic means, 30 days before the declaration or something like that. And so a landlord going with a 30% rent increase is probably violating the price gouging statute. Like most of these executive order, I should say, price gouging executive order. Like most of these executive orders, it's enforced exclusively by the Attorney General's office. And so if a tenant is dealing with that, they should contact the Attorney General's office right away and say, hey, look, my landlord's trying to go above the 20%, they're price gouging. The penalty is massive for that. I believe it's $10,000 per violation. And so yeah, contact the AG's office. They are very active in enforcing the governor's executive orders, especially the ones relating to tenants that we've seen them, like I said, very active in, and we're grateful for the effort that they put in since March. They basically had to create a department to do this, and they got it on the ground right away and have been explaining to tenants and landlords around the state what the rules actually are and how they impact them, and occasionally having to enforce it.
Okay.
Yeah, thanks for posting those. They do prefer, it seems, internet requests. You can actually call them as well. But Eric just posted the links where you can file a complaint to the AG's office about one of these violations, and they seem to get to those more effectively, or efficiently, I should say.
Yeah, and they those all the forms are available in multiple languages too, which is helpful. And yeah, I mean, if you submit it, they will contact you and ask if you'd like them to intervene if they do identify a problem. So, all right, one other question, unless we get some submitted here. Britta says, I keep hearing mixed signals about how evictions are different during the pandemic. An explanation for Minnesota renters would be great.
So what do you think she's getting at here? The process of the evictions, the ability to file them? What do you think Britta's asking here, Eric?
Well,
I guess I can answer it in both ways.
Yeah, I mean, maybe we just say, yeah, I guess how things are different in terms of what can be filed, and then also the ones that can be filed. I guess maybe it's an overview of some of the previous slides, and maybe talking also about the no notices to vacate allowed, because there's a little bit of lack of clarity in that in the Star Tribune this week.
Right. So yeah, the executive order that we've talked about, the most recent governor's order, which is, I believe, is that 79? That's the one we're still using, right?
That's the current eviction suspension order,
yeah. That specifically doesn't allow a landlord to either file an eviction for all the reasons that we talked about, non-payment of rent, a pet, unauthorized document, whatever. Nor can a landlord terminate a tenancy right now. Okay, so that's different than an eviction being filed. In fact, I'll pull up the exact language so I can make sure that I'm reading exactly what it says, because the wording matters a lot. Yeah, so the landlord can't file an eviction, and cannot, sorry, I've looked at this so many times, you'd think I'd have it exactly where it would be.
That's all right.
Give a notice of a termination, a notice of non-renewal of lease. Neither of those work right now. So a landlord can't give a notice. So what the difference is between a notice to vacate or a notice of termination and an eviction or a non-renewal? An eviction is the court case. An eviction, unlawful detainer, those are the court cases. That's not how most leases in Minnesota end with evictions. I don't know, 700,000 rental households in Minnesota. And each year, regular year, there's maybe 17,000 evictions filed. So that's not all the places, right? Most tenancies don't end in an eviction. An eviction costs a landlord $300 to file. They don't want to file them, and they take time. 20 to 30 days on average prior to the pandemic. So most tenancies end either by the tenant giving a notice to vacate and leaving when they want to. Hey, my 1-year lease is over. Landlord, I'm going to leave at the end of my year. Okay, great. Or the landlord says, you know what, you've been here a year, but I don't think I want to do another year. In fact, I want to move back in, or I'm going to rehab the place and renovate it extensively and charge triple the rent, whatever, right? General rule is the landlord doesn't have to have a reason to non-renew a tenant. That's the general rule. They don't need a good reason to say, I'm not going to renew your lease, or here's your notice to vacate. And we have to explain that to tenants over the phone all the time and say, hey, you know what, the landlord gets to decide. I mean, this is their property. They can decide not to renew the contract. You had a 1-year deal, not a lifetime deal. And so that changed during the pandemic. Now a landlord can't say, I want to end your lease just because your lease is over. Not allowed to do that. They can't file the eviction right now either. So that's got a very large impact on landlord-tenant law. It's not as big as the I can't file an eviction as a landlord, but it's still a big impact on landlord-tenant law. Landlords can't just end the lease because they decide that they don't want to renew the lease. Not allowed to do that. So anyhow, that is a more thorough explanation of the governor's order creating this moratorium on evictions. It's not just evictions, it's also terminations of tenancies or notices to vacate. Going a little bit different direction with that question, which is the process the same for an eviction? Well, I don't think any court process is the same as it was 10 months ago in this state, frankly. Zoom hearings are now the norm. And that changes things because many of our clients, the technological capabilities aren't what you need to be able to appear in a Zoom hearing. They do have it generally set up where a phone call can suffice, that the tenant can phone into the hearing. There have been times throughout the pandemic where tenants were allowed to appear in the hearing itself. And I think the courts right now aren't really doing that because of the recent resurgence in COVID-19 cases. And so to start with, when it comes to the process, check the rules right then with the clerk. They're not going to make it hard for a tenant to appear or a landlord to appear correctly. If it's a Zoom call, they're going to make sure that you got the right way to do it. They're going to let you know how to do it. If there are hearings being held, they're going to tell you where to be and when to be there. And they're going to answer those questions about, is my case going to be in person? Is it going to be over the phone? Is it going to be a Zoom call? So the process has definitely changed. I think, oddly, this isn't really the focus of what we're talking about today, but we have had historically 3 main topics, reasons why people call our tenant hotline. There's about 75 that we keep track of, but 3 of them account for more than half of our calls most years. And those topics are repairs, a landlord not fixing something from the tenant's perspective, evictions, usually where the tenant hasn't paid the rent, and security deposits. Security deposits, there's a chunk of tenants that when they are trying to recover their security deposit, they've actually left the state. They've moved out of state. A lot of college students get their deposit kept and they want to sue the landlord over the deposit. They want to have their shot in court. And it's been one of those situations where under the conciliation court, small claims court rules, the court official, the judge or the referee, had the discretion to allow a distance hearing. So a phone call hearing. It wasn't going to be a Zoom hearing last year. This year probably would be, because Zoom has just become part of our world, or Zoom equivalents. And so I think going into the future, the possibility of distance hearings at request by one of the parties or by agreement of both of the parties, or maybe just by request of one of the parties, might be much more agreeable to courts because they've realized that they can do this. This year, they've been forced to do those because many months it's been the only way they were going to do any cases at all. And that might continue. And so it's either shut down the courts completely, which we don't like societally, or let's figure out a different way to do it while it's still as safe as it can be for everybody. But this has opened the door to courtrooms thinking, hey, maybe there's a different way to do court. Maybe we don't need to make people fight traffic and go downtown in Minneapolis or St. Paul and get all formally dressed. There's a lot of ceremony that goes into a court hearing. And there's an argument to be made that a lot of it isn't necessary. but I mean, you have a judge sitting at an elevated spot wearing a robe and slamming a hammer down, which doesn't make a lot of sense, except that's what's been done. This year has really forced the judicial system, I think, to analyze, okay, what are the essential components that we have to have? And in the end, what they always come up with is, well, we're trying to figure out what's fair, what the rules are, and apply them as fairly as we can. Do we need the robe? Do we need the gavel? Do we need everything else? It's ripe for reexamination. These are, 1,000-year-old concepts in a lot of ways. And so maybe this pandemic will create this concept of distance hearings being more judicially acceptable going forward. Longer answer than we wanted. Sorry, I get off on tangents. Give me a different question.
Oh, there's another question, but I wanted to add some to this too, and maybe you covered a little bit because I got sidetracked. But there's also an effort by a lot of legal services groups throughout the state to create, and some of the courthouses to create kiosks, legal kiosks, and there's going to be multiple types of those. And I'm going to hopefully not get this wrong, but I think one of them is more of a kiosk, it's going to be in a safe place that's clean and away from other folks, and is a computer kiosk that a tenant or somebody that needs, it's not just renter issues, obviously, I think they can go to and get legal supports and information, and I think talk to a legal aid attorney or a volunteer attorney in some way. There's also going to be other types of kiosks that'll actually function with the court Zoom, is my understanding, and people will be able to participate and in some cases like access emergency assistance or apply or talk to somebody about those types of things. So
those aren't in place yet, or they are?
I think those are like being set up right now. I've not been on a recent call about it, but yeah.
And that's the kind of thing that can put somebody who's nervous about the tech, which many of our clients are, and I'm sure many low-income clients, like you said, not just in housing, but in a wide variety of judicial fields, would be nervous about. Is, can I figure out the tech sufficiently to, make sure I'm being heard and seen and having my day in court, whether they're physically in court or not.
Yeah. I did put in the chat the link to EO 2079, just so you can read it yourself, and also the FAQ that's on our website about that just kind of talks through what exactly the eviction suspension is in Minnesota. So hopefully that helps the person that was asking the question. If you're a renter, of course, you can always call our hotline too and get information about your specific situation, and the number is on your screen right there. So okay, we got another question here. Do you feel in the near future that Minnesota as a whole will adopt the rules for screening rental applicants that are now in place in Minneapolis?
Wow, that's a good question. So I'm a lawyer. One of the things that lawyers do is look at precedents. What has happened in the past? What has worked in the past? That sort of thing. What hasn't worked in the past? And there is a precedent for this kind of question, frankly, and it's actually pretty closely related. I don't know the year off the top of my head. I want to say 2005 or so. Minneapolis first, and then St. Paul both adopted application rules for renters, just for Minneapolis and for St. Paul. These were ordinances that set some new rules on the application process. These rules now feel very common because they're now rules that have been adopted effectively throughout the state. So Minneapolis and St. Paul adopted some more progressive rules on tenant screening, again, about 2005. And then 2010, 2011, somewhere in there, the state adopted very similar rules. Minneapolis and St. Paul, you could argue, served as labs for laboratories for these theoretical ordinances, right? These new rules. And I can recall personally seeing landlords talking in Minneapolis before that ordinance was approved in 2005, talking about how this was going to wreck the landlord industry, basically, that they would sell their property and go to another city where they're not so regulated. And then I saw those same landlords 15 years later saying those same things in Minneapolis when they were considering their new ordinances. So apparently they didn't leave the city, at least the first time around. Maybe they will this time around. Maybe the regulation gets to a tipping point for landlords and they decide, I'm going to start only being a landlord in Bloomington. I guess that could happen. But I think there's a real possibility, because what's going to happen here in Minneapolis, we're going to see if it works, right? Is this going to make it so every landlord wants to sell their property and get out of the landlord game? I seriously doubt it. I think that's one of the things that a landlord or a landlord group would say, but that doesn't mean that it's true. And so we're going to see. Minneapolis is going to have this ordinance in place, and maybe it's there for 3, 4, 5 years. St. Paul is going to have a similar one next March. And so we're going to have a sample size to look at, because, I mean, if you look at Minneapolis and St. Paul, I don't know how many rental units that is combined, but that's got to be probably 1 in every 6 or 7, maybe even 1 in every 5 rentals in Minnesota, right? I mean, they're just a lot of renters in those 2 cities versus most of the other cities in the state. So we're going to see if these are rules that will work. Now, the other possibility is that more and more cities will become progressive renter protection cities. St. Louis Park, Golden Valley, we're hearing now. And others have passed other types of ordinances in the metro area in recent years as well. I have a strong feeling that other cities might follow the Minneapolis Section 8 rule. Now that's gone all the way to the state Supreme Court, those other cities have the protection of, well, there's been a court case already decided on this. If we model our ordinance on the Minneapolis ordinance, then we're probably insulated. So I think that, will it expand? I think absolutely tenant rights are going to expand. Will it become statewide? I think that hinges almost completely on the makeup of the state legislature and the governor. I mean, they're the ones that write the state rules. I think there's also a possibility, because right now, just the political realities of what we're talking about here, the governor is Democrat, the House is Democrat, the Senate is Republican. And you pretty much need all 3 parties to agree to enact anything new. It's a lot easier to keep something in place right now than it is to enact something new. But let's say it stays the same way for 4, 5, 6, 10 years, whatever. Republicans in the Senate, governor has Democrat, and the House is Democrat as well. I can see the concept of legislators looking at what's happening with all these city, like I said, this patchwork of rules that I think we're starting to see. I don't think anybody wanted to design it that way. It's just where we're going, because the cities realize this is the only way that any kind of meaningful new tenant protections can happen is if we do it at the city level. So let's at least do it at the city level. But the legislature might say, well, wow, there are so many different rules that it's hard for everybody to follow. Let's try to make up rules that cover the entire state. So is there some chance that at some point the Republicans in the Senate might be more willing to at least consider new tenant protections in order to try to unify or make uniform throughout the state the rules? I don't think it's a given, but that might be the one place they figure that they have that kind of ability, where at least they can craft something at the state level that they have some control over, whereas at the city level, in Minneapolis, I'm not sure. I don't think city council members are party affiliated, are they, Eric, or are they?
Oh yeah, they are.
Oh, they are. They go, okay. Are there any Republicans in office in city council in Minneapolis?
No.
Okay. So that's pretty Democratic leaning. So they get to write their rules. The Democrats get to write the rules in Minneapolis. And that's not the case in every city, obviously. But it is the case in Minneapolis and in St. Paul. Again, a progressive slate of tenant protections. So at some point, does the state legislature say, well, we want to have some more uniform rules because going city to city, it's a little bit odd to have all these different rules. And I can certainly see that argument. It's a lot easier to follow for a tenant, for a landlord, for anybody in this line of work, if it's one rule for everybody in the state. But I think that we're going to see it spread beyond Minneapolis and St. Paul, almost certainly. How far it spreads is a different question. Will it be statewide? That's going to hinge on either the legislative makeup changing or sort of the thought process when it comes to landlord-tenant new laws at the state level changing as well.
Yeah, I think, I mean, that's a good example, a couple of good examples you shared. Another one I think is that we have a section of our website, because we get questions about it so often, is what are the minimum heat requirements in my rental unit? And that depends where you live. And I put in the chat the link to our table, which is not totally inclusive of every city in the state. You know, it's a little bit dated now. It's from a few years back, but it's because these things change on a local level all the time. But yeah, city by city, the type of minimum requirement just for heat can change. The dates when it has to be that amount and the specific temperature it has to be. There's differences, and that creates confusion for tenants and landlords. We're a cold state.
I mean, from the day that I took this job at Homeline in 1996, that was the first one that I looked at, the first rule that I looked at, that I realized there wasn't a rule, and it just kind of mystified me. In Minnesota, we should have a rule about it should be warm enough in your home, and we should be able to agree what that means. And so it's never been understandable to me that wasn't a rule. When a tenant contacts us on our tenant hotline about heat, the first thing I do is I look at that chart and I see what city they're in and what their rule is. And city to city, it varies, and sometimes very meaningfully, it varies. And it just doesn't make any sense to me at all, but that's what we have.
Yeah, so, okay, I think we answered that question. We did get somebody who joined us late. We got 8 minutes left here, so feel free to submit another question if any of the folks still on have them. But somebody joined a little bit late and is wondering if we can just do one more review of the status of the order in Minnesota banning or barring evictions. Does it have an end date? Is it likely to be extended? When is it going to end?
Yeah, so this is a question that we're asked a lot. You know, what do the tea leaves really tell us? You know, can you guess about this? Can you predict this based on anything? And honestly, it is a guess. If we're trying to figure out when we think the moratorium is going to end, I can give you the official answer, which is December 14th. December 14th, the state moratorium on evictions is slated to end. But it's been slated to end every month in the middle of the month since April, but it hasn't ended because every month the governor has reauthorized it and the legislature has not voted to end it. And so it's going to go perpetually until one of the key parties, one of the key players says time to end it. So how long will it go on? When do we think it will likely end? Well, I don't think it's going to end this month. I could be wrong. Maybe we'll be shocked by everything, but the numbers on the coronavirus seem to be getting worse and worse all the time right now. And so I'd be very surprised if the governor ended the peacetime emergency or the legislature voted to end the peacetime emergency. Again, you need both the House, controlled by Democrats, and the Senate, controlled by Republicans, to vote to end the Democratic governor's executive order with the peacetime emergency, and included in that is the eviction moratorium. So I think it's very unlikely it's going to end this month. I think another question is what's going to happen at the federal level. Will the CDC order that expires at the end of December, December 31, will it be renewed? January 1, President Trump is still the president. And so I think it might even actually be his decision alone to decide whether or not to extend the eviction moratorium through the CDC. So the federal backstop, which would be there even if the state moratorium went away. But could they renew it at the federal level? Sure. The last time they did it for a 4-month period. It was early September through the end of December. So I guess they could renew it for another 4 months. I think another new question happens on January 21st when President Biden takes over the White House. And will he enact some kind of executive order if President Trump doesn't enact an executive order? It's a fair question. I can see a 20-day gap very realistically happening at the federal level. At the state level, judging on the comments that Governor Walz has issued publicly, I think that the peacetime emergency will be ended by the governor when he thinks it's safe to end it, and not a day sooner. I think it's could the legislature vote to end the peacetime emergency? Sure, they could. I'm not sure. I think it's most likely to probably happen during the session next year. When does the session start, Eric? Do you know? Is it January, February?
I'm pretty sure it's right away in January.
Right away in January. So maybe they'll decide to end it. I'm not sure. And they could write their own rule, which might include a legislative moratorium on evictions for a certain number of days, or maybe it would hinge on, or months, or hinge on factors, outside of their control, like when the number of reported cases for the last 2 weeks gets to a certain low level, then they'll lift. I don't know. I'm sure there's some way to calibrate that if they wanted to. But it is a very difficult thing to predict when all these moratoria are going to be gone. And that's why since April, how we focus these conversations is, can a landlord file an eviction? What are the hurdles that they have to get past in order to be able to file? And right now we still have the two big ones, the state moratorium and the CDC federal order through the end of this calendar year. So we'll have to wait and see.
Yeah, and I was just looking up, I'd seen something I thought on Twitter yesterday, and House Majority Leader, somebody in the DFL had said that the hope was that they were going to have the special section this week, but it's sounding more like...
Can they do that? Don't they have to wait till the 14th?
No, or I mean, sorry, next week, but
sure.
I don't think they have to wait till the 14th. The 14th is at midnight is the end of the peacetime emergency, so something has to be done if they want to extend it by then.
Got it. Yeah, I think it's unlikely they're going to do it this month. I would really be shocked if they ended the peacetime emergency this month with the COVID numbers being like they are.
Yeah.
But
okay, well, we've got 3 minutes left, no pending questions, so I will delay a little bit here if you do want to send in your question. Otherwise, we'll end early. I'll just remind folks that our next session is on the 16th, so 2 weeks from today.
And that'll be after the 14th, the deadline. So we'll know, right? We'll know the answer to the state question about whether the eviction moratorium peacetime emergency has been extended.
Right, and potentially, they may still be in session then, but potentially
Sure.
we'll know about if there's any other funding for rental assistance. So, we'll be talking about that on the 16th, and the link to register is in the chat. And then, yeah, we will at that point make a decision about our schedule in January. But based on sort of what's going on with the suspension, likely that we will continue these sessions as we've had a lot of positive feedback so far. So, okay, well, I'm not seeing anything else here, so I think we'll close up shop a couple minutes early, and want to again thank everybody for joining us today, and hope you found it helpful. And yeah, thank you.
We'll see you on the 16th, hopefully.
Yes. All right. Goodbye.